Hello, welcome to Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jan Besson. Jan is a partner in her own law firm. It's Besson and Yarbrough. They're located in Los Altos, California.
Yes.
And Jan is an estate planning attorney. She's certified with California State Bar as an estate planning specialist. And she also teaches Medi-CAL planning in annual update type of programs for attorneys, as I understand it.
Yes.
So anyway, talked with Jan on various occasions about Medi-CAL planning, and I think that she has some valuable information to share with us in this area. So that's what we're going to talk about, is using Medi-CAL benefits for long-term care. Now, as we get started in this, first of all, I want to put our viewers on notice again, as I usually do, that we're talking about a complex subject here. This is, there's a reason we have attorneys like Jan that are educated in this area, and so we're just going to hit some highlights here. Another thing is that Medi-CAL is actually the federal Medicaid program as it applies in California, and each state seems to implement it differently. And so if you're watching this and you're a resident in another state, please be aware of that, and be sure again to get advice from your attorney who is licensed in your state. And so with that, I think we'll get started a little bit here. And I have a framing question that I developed, and that is, what if your spouse needs long-term care and you either haven't provided for it with long-term care insurance, or the benefits are running out for your insurance? How can you protect your family's assets? So that's what this area of Medi-CAL planning has to do with. So, Jan, why don't you explain to us a little bit about what are Medi-CAL benefits? Why are they important for providing for long-term care?
Well, Medi-CAL benefits, as you have mentioned, is a federal program. It's a federal Medicaid program, and it is a program that's administered in California through each county, and it provides the underlying insurance for health care needs for people without sufficient resources. In particular, they have a special program for long-term care residents. And in order to qualify for long-term care benefits, which will pay for skilled nursing facility residents, not for in-home care, not for board and care, not for retirement homes, not for assisted living, but rather skilled nursing.
Okay.
Which doesn't mean that you can't get Medi-CAL benefits for other things, but not through this program.
I see.
So it is an insurance plan of last resort that's available to people who have those needs, so skilled nursing facility needs, and can't afford to pay it on their own, either through other private insurance programs, long-term care programs, or personally. In talking about this, I want to make sure that when somebody needs Medi-CAL benefits, usually it's a time of crisis. And it's a very difficult time for the family. And there are certain things that you can do to prepare for this. It's surprising how you can qualify for benefits, and you have to think of yourself as being indigent, but that does not mean that you don't have resources. But in preparing for Medi-CAL benefits, what's important is to have the documents in place that allow the implementation of the plan. So generally that's a durable power of attorney that has the authority maybe to make gifts or revoke trusts or and you're very clear about the kinds of gifting you want to do, maybe you'll want to get some trusts in place. But I am not one to take steps to actually implement a plan until the need is there.
Mm-hmm.
Because one of the fundamental principles of being eligible for Medi-CAL benefits is that the applicant, which is the person who will be residing in the skilled nursing facility, that individual really cannot have any resources.
Mm-hmm.
And that's a very potent part of somebody who's ill to give up their autonomy, to give up their assets.
Yeah, that's the
You
big
don't
deal.
really want to do that in advance,
I see.
but you want to be prepared
I see.
with the right kind of documents in place.
Okay. So I understand that you have to be actually like destitute to qualify for Medi-CAL benefits. Is that true?
Well, it's true in a way. It is the applicant who has to be destitute. The applicant, him or herself, can only have $2,000 in what's called countable resources. The program divides what you own into two categories. It's either countable or it's exempt,
Okay.
maybe unavailable. But there are a number of defined exempt assets. So your house, for example, if it's your principal residence, doesn't count. So it's a non-countable asset, it's exempt. So you can own a house and still be qualify for benefits. Your retirement plan benefits don't count. Your car doesn't count. Your family furnishings, your family heirlooms don't count. Certain business property doesn't count. A certain amount of other real property doesn't count. In addition, you may have some rental property that you co-own with somebody. If you co-own property and the other person refuses to sell, it's an unavailable resource. So there's many things that you can still own, but what you cannot have is the ability to liquidate them. Other than the house, you can liquidate the house, but the thing about Medi-CAL is it's full of exceptions, which is
Okay.
really why you need to see somebody who
Yeah.
knows all the exceptions.
Yeah. So that's why
So-
you need this legal help so that somebody can sort of help you chart the course.
It's very sad when I see somebody come in who has actually spent all their money before seeking legal help, and you discover that all that money didn't need to be spent. There are many ways to preserve it. One of the other aspects is that when you have a married couple and only one of the partners is going into a skilled nursing facility, the person at home is entitled to keep certain assets, and the value of the assets can be, again, this is the countable assets, about $114,000, almost $114,000.
So, in other words, the partner can still, husband, domestic partner, whatever,
Exactly.
can still have significant assets themselves and not jeopardize the benefits for the other partner that needs this coverage.
Well, people are viewed separately when that happens. However, when initially applying for benefits, there is a combined review. And yes, you're absolutely right. It's not only married couples. The laws in California do apply to domestic partners as well.
Yeah, registered domestic partners. So,
Right.
So we have to look for that little legal status, the
Yeah,
piece of
you
paper.
always have to look at that.
Okay.
So,
So then you can keep your home and still qualify? And what are
Yeah.
like some related concerns related to lifetime and death in the home?
well, okay, one of the things about having exempt assets, yes, you can keep your home. that's a protected asset in California. And at this point, you can have any value home. The state has not yet implemented the laws that one may have heard about being implemented in other states. California is still back in pre-93 laws. That's what they're using. So yes, you can keep your home. What is of concern, however, is if you do keep these exempt assets, then upon your death and the death of your domestic partner or your spouse, after the death of both of you, the state will ask for you to repay what was used by the state for your medical care, what Medi-CAL has paid. And we're not talking about Medicare payments, and we're not talking about food stamp programs. We're only talking about Medi-CAL benefits used.
So but what we're saying, though, is that basically both partners, both spouses, get to use the property for their lifetime, and then when both of them are deceased, now the state's going to show up with a claim and saying, here's a bill.
Here's your bill. Here's your bill. You paid for it. So there are ways to avoid that bill.
Okay.
In fact, one of the rules says that what is owed, what you have to pay back to the state, is the amount that the state paid for you up to the value of the property owned. That's whatever kind of the assets owned, the value of the assets owned by the Medi-CAL beneficiary alone. Not owned by somebody else, not owned by the spouse, not owned by the domestic partner, but by the person who was in the skilled nursing facility who was receiving Medi-CAL benefits. Well, one very easy way to protect your assets is to not own any property when you're receiving after you've begun receiving Medi-CAL benefits. So if you transfer ownership of the house, let's say that's your only asset, you transfer the ownership of the house to your spouse or your domestic partner, then at your death you don't own it. And if you don't own it at your death, the state cannot come back and recover against it.
All right. Now, this just comes to my mind, though. I mean, there's like side effects for this, isn't there? Like if you have a dissolution of the marriage later or something like that?
There are all sorts of considerations, and this is really why you really need to talk to an attorney, because if you have a blended family or if you have different testamentary dispositions, different ways you want your estate to pass.
We've got kids on both sides, and mom gave her house to dad. Oh my God!
But there are all sorts of ways to deal with that, and that's what comes with the pre-planning. So you know there are other ways to protect assets. If a house is owned in the form of a life estate, that's not recoverable. So I do use oftentimes trusts, perhaps irrevocable trusts, perhaps life estates, to deal with the issues of different dispositions of your estate, different ways that you would want it to go on the death of the first or the second of you. So there are ways to accommodate that. Okay. It's part of the estate planning that you really want to be careful in doing.